You just got founder shares in your startup, so why is everyone asking for your spouse's signature? Even if your spouse isn't on the cap table, even if you don't live in a community property state, their signature could make or break your future fundraising, exit, or Section 83B tax election. Let me explain why this tiny signature has huge potential legal impact and what founders need to know before it's too late. I'm Corey, a startup lawyer helping entrepreneurs decode law, technology, and innovation. Today, we're tackling one of the most overlooked legal tripwires in early stage startups, and that's the spousal signatures on founder stock grants and potentially Section 83B elections. Okay, so what's this video going to cover? You'll walk away with clarity on why your partner's signature matters even if they're not involved directly in the business, what venture capitalists expect in your equity documents, and how to avoid future tax and ownership disputes. So, what is spousal consent and where does it show up in startup paperwork typically? Why does it matter for both restricted stock purchase agreements and potentially Section 83B elections? What happens if you don't collect the signature at the appropriate time? And how to future-proof your cap table for investors. Let's look at spousal consent in restricted stock purchase agreements. Most restricted stock purchase agreements end with clauses such as in an exhibit or an attachment, I, insert your spouse's name, the spouse of insert founder's name, have read and approved this agreement, etc., etc. Why is this language there? Because it protects against claims to the company and to the founder if things go sideways in the future. Examples would be divorce or an untimely passing in an estate situation. So what's the key reason? This ensures that repurchase rights and vesting terms can be enforced by the company and the founding team, even if the founder's personal life changes. So next, let's look at an Exhibit A or an Addendum A, which is a pre-signed stock power. Your restricted stock purchase agreement may also include one of these exhibits or addenda, and it's a form that gives the company the right to repurchase your unvested shares or your shares subject to a repurchase option. Now, if you're in the founder situation, shares are most likely subject to a repurchase option and not necessarily traditional employee vesting. Be on the lookout for a future video on those differences. What happens without your spouse's signature? Without your spouse's signature, that right can be challenged or delayed to repurchase those said securities, just when the company may be trying to raise capital or to sell the company itself in a merger acquisition transaction. Now, what if you say, well, Corey, we don't live in a community property state. Even if you don't live in a community property state, you're still likely to want the signature. Now, why is that? Well, because first, it's going to give clean ownership records, and those will matter everywhere. Secondly, it prevents disputes, and that's not limited to just California or Texas or states like New York that have community property laws in place. Finally, investor standards are the same pretty much across the US, and investors are going to want to know that you've got your I's dotted and your T's crossed. And finally, it's not just good legal hygiene, it's really good startup hygiene for setting your business up with the proper foundation. Now, let's look at the spousal signature for Section 83B elections. A quick note on Section 83B elections, I'll have another video on this topic as well that goes a bit more in depth, but traditionally, Section 83B elections did not have an actual standardized IRS form. As of late 2024, the IRS has rolled out a template form that can be used, but it's optional. Now, in this context, the spousal signature for Section 83B, while it's a personal election for the founder receiving the stock, purchasing the stock as a founder, even if you owe $0 in tax, the spousal signature can help to avoid or prevent, first off, future disputes with the tax authorities. Second, divorce-related tax confusion. For example, do you file jointly or separately? Those things may change. Also, spouses may move over the course of the ownership of the stock. So you may start off in one state and end up in another state, and these facts change, and where these documents aren't signed, it can create ambiguities that may not have existed on the day you receive your grant. It can also lead to audit delays, for example, depending on whether or not signatures exist. And again, if you're in any sort of marital dispute or any sort of estate-related matter because someone has passed away. So another tip, filing with a spousal signature, it doesn't mean there's joint ownership. It does help to prove shared understanding. And that's important because, of course, that spouse would have had to sign those documents, and it supports the position that they did at least have to read and understand what they were signing. You may ask, well, what happens if you just skip the signature? Well, nothing right away. I mean, the only time you'd see something like this come up is going to be in the future when you have an issue. And if you don't sign it, you're risking the repurchase rights of the company potentially being unenforceable, cap table disputes potentially during due diligence. If you're in a mergers and acquisition or a financing round situation, there could be a delay in closings. And also from the standpoint of marital or estate matters, there's potentially a weaker position of that founder, and the company may be potentially dragged into the middle of that marital dispute or that estate dispute because all signatures are not present. Okay, so let's recap. Spousal consent primarily protects repurchase rights of the company, as well as clarifying for the founder that the repurchase agreement applies to both the founder and the spouse. It ensures cap table enforceability. It signals to the IRS and the tax authorities awareness of the property itself. And it's an investor typically non-negotiable from the standpoint of good corporate hygiene. So don't skip this step. It's not just about the law, it's also about leverage. And again, you may make an assumption around how things will look in the future. The one thing that we know is the future is always uncertain, and it's best to have these ducks in a row up front. Finally, note that with all things tax and legal, this is a general summary. Everyone watching this will have to review their specific facts and circumstances and speak to the relevant professionals for their own life. Join me on the path to decoding law, technology, and innovation to grow your business. Don't forget to like, share, subscribe, and hit that notification bell. Until next time.